Shri has been my collector in the past. I used to be the assistant collector, but I think the privilege of asking questions will continue. So on the first question, if the issue settled by a regulator in the sense of tariff, is that the question? No, we don't go into tariff. That's not our domain. That's strictly the domain of the regulator, sectoral regulator concerned, whether in electricity, whether in telecom, etc. But if the behavior of the entity is in some manner anti-competitive, then we come in. If they are not really following what they should be doing, if at all they are combining with other entities, then there is no process. Otherwise, on tariffs we are not handling. The second question is, what are your views on the charge that auction of some resources will lead to a sharp increase in the prices of the end product? Well, we had looked at this in our committee, and our view was that perhaps this is being exaggerated. What will be the impact on the high prices? But even if there is an impact, our recommendation clearly was that the subsidization, if the state needs to do by way of public policy, should be done at the end and not at the intermediate stage, not at the raw material stage, because it gets very complicated and one doesn't know who is really getting the benefit and in what proportion and whether that's fair or not.
Sir, the next question is by Ms. Preeti Shah, Editor Insight, who also represents the Consumer Education and Research Center, Ahmedabad. Kindly, Shri. The slightly long question, in fact, two questions grouped together. Is there any representation of Consumer Protection Ministry and activist group in the Commission itself? Are there consumer experts, consumer group representatives on the Commission? Should you not have one or more such consumer representatives so that the work is closer to the common man? Section 18, protect interests of consumers. This is the first question, sir. And question 2 is related. Do you agree that among other criteria in selection of members, one criteria should be that no member should be a paid employee of a monopoly / multinational? Please advise.
In regard to the composition of the Commission, the Act very clearly provides that anybody who is a full-time employee anywhere else cannot be a member of the Commission. They are all full-time servants of the Commission and therefore appointed by the government. So there is no question of anybody being an employee of any company, multinational or otherwise, during the period that they are members of the Commission. And the section relating to the background of the members has a very wide mandate. They need to have so much experience in various kinds of sectors. So it doesn't preclude, of course it doesn't specifically include consumer related organizations either, but it doesn't preclude them. So it's actually in a sense the prerogative of the selection committee, which is headed by a Supreme Court judge and which decides and recommends whom to take, which is based on the number of or the kind of people who apply. So it's an open process where anybody can apply as long as it fulfills the broad criteria. The selection is recommended by that committee, chaired by a representative of the Chief Justice of the Supreme Court. That's how they are appointed. And nobody can be in any other full-time employment.
Can I?
You have a supplement?
Yeah, just a clarification that in case you're talking about the members of the Commission, but would that also translate to the wise men, the group of advisors that you have recently formed to advise the Commission on various issues? So would that also, can that include consumer representatives and also the other motion that you said that no employee should be there?
Of course, it can include. Certainly.
Madam just wants to. Sir, the next, and there is a related question from Mr. Abhishek Avasti, who is also from CERC, but it is almost the same, so I will not repeat it. Sir, a question from Mr. Sanjay R. Shah, Ahmedabad branch of Institute of Chartered Accountants of India. Sanjay ji, just, okay. If, as you said, Competition Act applies to even government-controlled companies, what about oil companies who act in unison for controlling petrol prices even after international prices are falling?
Good question. We've taken note of that.
Next question, sir, by Mr. R.B. Bhimani of Arvind Mills Limited, who is the company secretary. Mr. Bhimani, please switch off your mic, your mobile, gentlemen. We are still not sure about the threshold limit up to which the Section 5 will not be applicable in case of merger of group companies carrying on similar business will be subject to Section 5 or not. Please explain, Mr. Bhimani. Just give a mic out there.
See, the target company exemption, by the notification of, I think, March 2011, isn't it? That is 250 crores assets or 750 crores turnover. Not and, or. So even if one of the two is not satisfied, the merger provision will not apply. Is that your question or is some other question?
In case of amalgamation of both the company, the resulting company threshold limit.
Right?
If there are two companies, after amalgamation, what will be the threshold limit up to which this section will not be applicable of the amalgamated assets?
The 250, 750.
That is before amalgamation, that is individual company. In case of the amalgamation, after amalgamation, if the amalgamated asset exceeds some limit, then this section will be applicable. I am not sure about that.
This section 5 will be applicable. There the limits are specified. This is only an exemption in relation to target companies. But otherwise the thresholds are prescribed in section 5. So if you have the act, you can have a look at what are those numbers.
I may also suggest that in case of very micro questions where there are specific issues of facts and figures, you may send an email to the commission and you will get the response.
And second question is to the amalgamation of the group companies carrying on similar activities, whether it is exempted or it is covered.
If they are wholly owned subsidiaries, they are exempted. If they are not wholly owned subsidiaries, they are not exempted. That's the regulation of, I think, February 2012.
One question, sir, by Ms. Krishna Mehta, who is the Chief Minister's Fellow in the Secretariat. Robert, and the question is, please raise your hand. Robert Bohr has argued that competition laws can produce adverse effects when they reduce competition by protecting inefficient competitors and when costs of legal prevention are greater than benefits for the consumers. What are your comments on this?
Firstly, tell me what is the Chief Minister's I haven't come across what Robert Bohr has said, but competition laws can produce adverse effects when they reduce competition by protecting inefficient competitors. How will that happen? And when the costs of legal intervention are greater than the benefit for the consumer. This I can understand. And yes, the costs of enforcing competition in a certain area or a certain sector or at a certain point in time may be quite high, the benefits immediately may not be much. But how does it produce adverse effects by reducing competition?
By protecting inefficient competitors?
Inefficient
There is a
competitors?
question, sir, that it can produce some adverse effects.
Sir, I have one example for that.
Yeah.
Sir, in fact, I had asked the same questions. Sir, I had given an example in my questionnaire. The example was that, suppose, let's say, there's a market in which there is no product differentiation and the market has very low fixed costs. And by historical reason, by first entrance, company A is the dominant player in the market. And company B then enters the market, so company A reduces the prices below cost, predatory pricing case. But then, since the since the market has low fixed cost and no product differentiation, there are no entry barriers as such. So, as soon as it will raise the prices again, new entrants can come into the market to give competition. So, sir, in this situation, what policy will CCI follow? Whether it will keep consumer welfare, consumer welfare the prime importance, or will it ensure competition?
So you see, the basic objective is to ensure competition, and predatory pricing also is an offence, as was brought out in the case of National Stock Exchange versus MCX. You've seen that order, and this very often happens where the incumbent entity tries to play with the prices so that there is restriction on entry, which serves as an entry barrier. So entry barrier is anti-competitive, predatory pricing is anti-competitive, and the basic objective or function of competition law is to encourage competition and to make sure that markets function efficiently. And hopefully they will, at the end of the day, subserve the interests of the consumers. But it is not, as I mentioned towards the end of my speech, it's not the only and the main objective of competition.
Sir, there is a question by Mr. Vaishal Dave of Yogesh K. Dave and Company. Mr. Dave. The question, sir, is recently there has been a sort of turf war between sectoral regulators and CCI. This would be a serious setback to an institution which has the power to bring the true benefits of market economy to consumers in India. Can this be checked?
Well, first let me say that this turf war between market regulator and sectoral regulators is not unique to India. It's something which has played out at different points in time, depending on the evolution of